hell, I could pull Jackie over because
and that's often happened, I understand. So,
Well, yeah, but and you might very well do that, Steve. But on the other hand, we don't give refunds to people who go to court and get declared innocent. I mean,
but this is different. You're towing somebody's car because they're accused of
because
something
they're
that they
suspected,
can't try.
right? They're
And
suspected.
then they had nothing. They didn't do anything wrong.
Well, like you said, we don't do that in Will County, and the ordinance we're writing for is Will County,
I
right?
said that because I'm praying to God we don't, but
Keep praying.
But I think at the moment we should let the lieutenant explain the legislation first, and then we'll get into the details of it. But what point well taken though, Steve. So.
The administration fee is separate than the towing fee. Basically, the vehicle is towed. They can either go to the hearing within 45 days. If they want their car back prior to 45 days, they've got to post the bond that is equal to what the fine would be. And then we would sign a release form. They would go to the tow yard, at which time they would pay the towing and storage fees. So the county would not be liable for the towing and storage fees at any time. Nothing has changed on the way we do arrests or on the way we do towing right now. Right now they have to go to the impound lot and get their vehicle back. All they would be doing is coming into the station. We would give them some type of certified paperwork that they would bring back to the towing company so the tow yard knows that they paid the fee, and then they would be liable to the tow yard for any storage fees or any towing fees. I'm not sure, I haven't talked to our traffic supervisor. I'm not sure if we charge towing fees because there are times where we actually impound cars on seizures where we're actually allowed to seize the car and then go through the Article 36 court procedures and auction them off.
I want to interject just a little moment. I understand we were having Wi-Fi problems for a moment.
Still am.
But I've just been told it's back up now.
Oh,
So.
I'll try it again.
If you have a Wi-Fi problem, turn off the Wi-Fi because you're all connected to the satellite. You connect via the satellite.
Oh,
But I think it's back. I didn't do that, Bruce, and I've got it back.
okay.
I'm glad you have it back. I'm on the satellite and that's where I'm staying for the time.
Okay.
I'm sorry.
I'm going there, thank you.
If you look on the back of page number 2, these are what the legislator is allowing us to impound these vehicles for. So it's not that we're just going out and pulling people over and giving them tickets and impounding their vehicles. So most of these are serious offenses. It goes anywhere from a DUI, cannabis, any offense, Controlled Substance Act, attempted commission, Chapter 24, driving while your license is suspended. And then the next page, expired driver's license. If it's expired greater than a year, as far as we're concerned, you don't have a license after 1 year. Not having a driver's license. If you have a warrant, you're driving the vehicle, we stop you, we can tow the vehicle there. Any misdemeanor or felony offense, the vehicle is involved.
How's this going to mesh with the medical marijuana thing? Are we going to have any problems with that? Do you think any confusion?
No, I haven't really taken a look at that.
Because somebody's just gone to buy their medical marijuana and they're driving home with it, and I don't want to get...
Well, I would think that they would be in the statute what they can carry, where it could be carried. Obviously, they're not supposed to be driving a vehicle if they're under the influence of cannabis at the time, so...
But they would have possession of it, though.
But that's medical. That's law.
They'll have a car.
But
They
cannot
can't be
bring-
under the
they can't be under
influence, just like you can't be under the influence of any other prescription medicine when you're driving.
Right.
But it's a difference to have a prescription in your car, as long as you can show the prescription, you know, it is.
Jackie?
I haven't heard of anybody getting arrested for Vicodin. I mean, it says on the bottle.
Sure, yeah, if they were to get in an accident that were found, they would be,
If they
yeah.
get in an accident, I get that,
Yeah,
but I mean, I
well,
haven't heard of anybody being pulled over for
Nobody's
prescription
pulling them
drugs.
over unless they're driving erratically or they get in an accident,
Okay.
which would be the same situation
Okay.
with the
All right.
medical marijuana.
Well, the standard for stopping somebody selling statute is cause to believe. That's the standard, right? Cause to believe.
Right, there's gotta be probable cause to pull them over.
Right.
And most of the time, our drug arrests on the bike are people who don't have a prescription, actually, for their possession.
Yeah, that's a different story.
Could we go into the specific procedures for a hearing, what we have to have?
Sure.
Okay.
The one important thing here is the storage fees is actually imposed to the registered owner of the vehicle. It's not imposed to the person driving the motor vehicle. So we have to make notice to the registered owner of that motor vehicle within 10 days, if we didn't do it on the scene, that their vehicle has been impounded. And then within 45 days, we have to set up some type of put them through the administrative hearing. If they do not come in prior to pay the bond. The contention is, once they come in to pay the bond, we will set them up for a hearing, and we will actually give them the hearing date when they come in. I've talked to some other municipalities, and about 90 to 95% of the people who pay the bond do not show up for the hearing. They basically default on it because they know that the vehicle was properly impounded at the time.
What I was concerned about was setting hearing dates, because we have to have a hearing within 45 days. Delays in setting a hearing date, because my understanding is that these storage fees would mount up through all that time. I don't know what they're going to be, but if we don't have a fast enough process and they get a hearing date on the 43rd day, that could be a considerable amount of money. What are you going to be proposing, do you think, the Sheriff's Department, as far as our two hearing officers? Are they both going to be handling these cases, or are you just going to have one specializing in these, do you think? Or?
No, we would set them all on one date.
Okay.
As I said, if 90% of the people don't show up, you're not going to have that many of the other hearings. If the problem you're going to have is if you want it sooner, you're going to have to set up another hearing. That is not the same hearing date as what you currently have. What we do now for traffic court is we just send everything to traffic court within 45 days. As I said, 95, 99% of the people actually pay that bond prior to the hearing, so the storage fees would not be.
They post the bond and get the car out?
Correct.
Okay.
Would not be racking up at that time.
And if they're found innocent, they get their bond back?
They refund the money if the hearing officer finds them not guilty. Which is going to be another issue that we're going to have to take care of at the hearing, because right now we don't post any bond for any type of administrative adjudication. If they're found guilty at the hearing, then they pay their money.
We're going to need to work with you on the mechanics of all this.
Yes, we're actually we're dealing with the circuit clerk and also sustain the ordinance software that we currently have for the administrative hearing. What we're trying to do is actually use the front end of the e-ticketing software, which is report me, so we don't have to go into the sustain system, which is a little more time consuming. One of the issues there is we're dealing with the circuit clerk is there is a fee that would have to probably be rebated back to them for every ticket that is issued, and they can advise on that later on.
Okay. You said this was actually, this legislation was basically amended to include counties, so this is already in effect for municipalities?
It's been in effect for 2 years.
Okay, so this is, as soon as we change this, if we enact an ordinance, we can start doing this.
January 1st.
Oh, we have to wait till January 1st. All right.
Mr. Chairman,
Yes.
point of clarification, Lieutenant Contra, when we talk about the administrative adjudication of these fees, for the most part, aren't we talking about towing cars that are legally parked? And if you get stopped for a DUI or a suspended license or cannabis, you're going to court. You're not going to administrative adjudication.
On cannabis, we can send you if it's under 10 grams.
Okay, so that takes care of cannabis, but the other stuff, most of it's going to go to court.
Correct.
Okay.
Yes. The warrants would go to court, the DUIs would go to court. This is not for, Mr. Freefeld said, for parking violations or anything else. It's all listed in the beginning of the chapter. So we have to serve a notice upon the interested party, which is the registered person with the Secretary of State, and that has to be done within 10 days. And then we have to set a initial hearing no later than 45 days after the date of the mailing of those notices there. And everything else has to be conducted by an attorney with a minimum of 3 years, which are the standards for the administrative adjudication, so there's nothing that's going to change there. The hearing officer already has these requirements in place. And then the hearing officer will give a written decision of whether sustaining or overruling the vehicle impound. And then here's where it says that the administrative fee posted to secure the release of the vehicle shall be forfeited to the county or the municipality. And Mr. Balch, here's where your concerns come in. It says all final decisions of the administrative hearing officer shall be subject to review under the provisions of the administrative review law. I'm not too familiar with that. I'm pretty sure Mary Kate can fill you in. But then it says unless the county or municipality allows an enabling an ordinance for direct appeal to the circuit clerk having court jurisdiction over the court, county or municipality. So if you want us to write the ordinance that way, we can write the ordinance where they can appeal to the circuit clerk.
What I would like to see is where, because I know I've heard stories from people that live not in Homer Glen, we have the sheriff, and the sheriff does a good job there. But I've heard where people get pulled over coming home from work in evening because they make a left-hand turn and they touch the yellow line on the other side of the street, and then they're accused of being drunk or under the influence, and the car's impounded, and they have the towing fees, and they're all aggravated because they were not drinking, and they're found innocent, and they still have to pay the towing fees. And to me, it's just a way for the city to make a lot of money, and that's a flaw in the way the law was written. But I'm not on that board. I'm not a state rep. I'm on the county, so I'd like to make sure that when we say we're going to do it, that we don't have that flaw. We make the words mean that if you're guilty, you pay. If you were pulled over and you found innocent, and basically what's going to come down to is DUI or under the influence or something like that. Because like you said, they're going to go to a regular court if they're found with that they're illegally driving.
Well, most DUIs take anywhere from 6 months to a year to be adjudicated in the regular court
You know,
system.
I wouldn't even have a problem with them posting a bond, but they get their money back if they're innocent.
Well, that
You know,
would be where you would send them.
But
to the
you're
circuit.
saying that the person would have to appeal it, and I don't think that's right to have them go through another legal jump when they were totally innocent in the beginning.
They only appeal if they're found guilty.
No, I'm talking
And
about
then-
the towing charge. You gotta pay the towing charge whether you're innocent or guilty, and that's where I have the problem. You know, and we have to, if we're gonna do this, we should do it the right
I
way.
will say this, if there are municipalities, municipalities are a separate issue from the county, and as you say, the
Right.
sheriff does a very good job. But if there are municipalities out there where there's a systemic problem, there will be attorneys jumping all over it to file class action suits, because they make a lot of money off of that, if you've got that going. So I mean.
I mean, I don't see a problem with saying if you're innocent in court, you're in adjudication, you go to the hearing and they find that you're innocent, then you're returned the money that you put up for your car, your towing fees. If you're guilty, then you gotta pay it.
Then
Well,
those
you
towing
shouldn't have to
fees
go
come
to
out of the
another-
county treasury, because the company's getting paid for the tow. So
But
that's a
then-
decision that has to be made.
But
And
the
the county
point
can
is,
do
if-
that,
if-
that's a
if
policy
the
question.
police, when they pull you over, they have to have probable cause.
Correct.
But that doesn't mean you're guilty. Probable cause means maybe you're guilty. So if they think you're guilty and you're not, just because they want to make an arrest, and I'm not saying we're going to do that here, but you always got to look at the consequences that can happen, not just because it sounds good. Well, what if? And that's the problem. What if the police officer pulls somebody over, did nothing wrong except come home from work late, and then drive over the wrong yellow line or touch it, get yanked over and say you're under the influence when you're not? And then they gotta pay all these fees. That's wrong. So why not say if they're innocent in the adjudication, then you don't pay anything? You, all right, I can.
Well, if the county wants to, I mean, that's up to your
Yes,
board members.
that's kinda
If they
where I'm
want
coming
it,
from.
fine.
I understand what you're saying, Steve, but the other side of that coin is that if a police officer does, in good faith, believe that there's in this case, cause to believe, or let's say it's a criminal case, and they have reasonable cause to believe that some crime has happened, and they prefer charges, and there's a trial, and the person is acquitted. That's like saying, okay, now the state didn't prove its case, and so now the state's obligated to pay for that defendant's legal defense fees because they lost the case. And I can't think of any jurisdiction where that's the law, that if the state loses the case, that they got to pay for the defense expenses of the defendant. And we might decide to adopt that type of posture here in this county on these administrative charges, but then we're opening ourselves up to a real drain on our treasury, or a real chilling effect with our deputies as far as trying to enforce these laws. So we can do it.
Well,
but
if
we
they
have to
pull
debate
somebody
that.
over for a DUI and they blow,
Mhm.
and nothing comes up,
Mhm.
but they're considered under the influence because they did the sobriety test.
Mhm.
Okay, they impound the car.
Yeah.
Now, if you go to court and you say, hey, Judge, I worked 12 hours and I'm coming home, and I went over the little yellow line a little bit when I made my turn. I was able to drive safe, except I screwed up a little bit.
Yeah.
All right, now I got a $500 towing fee, and I got a storage fee, and I didn't do anything wrong, in my opinion.
Yeah. Well, we have to express the discretion of our law enforcement officers. You know, are they using common sense or not?
Well, I have no problem with the law enforcement officer pulling you over and saying that. What if they decide, in their opinion, that you're impaired?
Mhm.
All right, so now they impound your car, but you're not impaired. It's their opinion versus the world, you know?
Yeah.
So you go to court and you see it, you sit in front of the adjudicator, and they say, no, this person shouldn't have been pulled over.
Yeah.
Okay, so now the officer's overruled,
Yeah.
and the person's innocent, but the person still pays $500 for a tow fee in storage.
No,
That's wrong.
I see your point. So
That is wrong.
when we start getting to the nitty-gritty of crafting together the rules for this for our admin courts, make that argument when this committee starts doing it.
But
And
I agree, we need to, I like the idea of doing it. I
Mhm.
mean, I don't, no problem with doing it, it's just that one little thing
Yeah.
that the people need to be protected from.
okay.
An overzealous policeman, and there are some like that. I'm not saying all of them, but you know,
Right.
every trade has somebody.
No, I get you. I appreciate your comments on it. All right.
Does this do mention that this law goes in effect January 1st? When do we have to?
Well, I'd like us to be ready January 1st. I don't like to wait until the last minute and stuff, so I'd
But
like
this
this
would
to
have
be.
to- I'd like-
Mr. Freibald's good to go.
Okay.
You get this and the court facilities fee, both become law in January. So
Right.
the board can't take any action until January.
Right.
So in both cases, so we might as well talk about both at the same
Right.
time. We'll work with the state's attorney's office and work with Bob
Right.
to draft the appropriate ordinance, have it reviewed by committee in advance of January.
Right.
So when January comes, then you can send it to the board for approval,
Okay.
without skipping a beat. As far as the discussion you've been having, you know, when it comes to DUIs, for the most part, you know, if there's a breathalyzer, a blood test, and if there's not, they have to walk the line. So there's video. You can't cover, Steve, if you have a road policeman, you know, he's gonna be dealt with in other ways. You're not.
This is gonna be a
And
very
that-
small number of people that I'm
Yeah,
talking
but in
about.
that small number of people, in the case of a road policeman, there's going to be consequences far beyond just the refund of the towing fee. So, I mean, I think you gotta focus on what you can actually deal with, but you're not gonna be able to make every wrong right. I mean, so, you know, that's my only observation.
What are we gonna base our fees on? Some kind of cost basis?
The sheriff is recommended $300. Most municipalities is $500. That would be up to the board's decision.
The statute reads reasonable fees, so
Reasonable
we
fees.
have to have some.
Just, wasn't there 2 fees?
There are-
The other fee is the towing and storage, which is paid directly to
Right,
the
that's theirs.
tow company, which is currently the procedure right now. So that is not an added,
That's
fee.
current. So all we're gonna do is the administrative fee, and we're talking about 300. And we're basing that on some cost?
Well, we're looking at overtime costs on the DUI arrest. You're talking anywhere for court time, anywhere from 5 to 15 hours of overtime, I would
Right,
think.
and you get a minimum 4-hour show
Minimum,
up
you
time.
get a
so
minimum
every-
3-hour show-up time. Most cases get continued.
Right.
4 to
so
5
there can be
times.
Multiple times.
Well, and again, the statute says it has to be a reasonable fee that's related to the investigation, the arrest, the detention of the offender, or related to the removal, impoundment, storage, or release of the vehicle. So expenses that this county's incurring related to those two things. So we have to have some kind of calculation as to what expenses we're incurring related to those two things.
Yeah, I just say to see some backup when we have the number to say, this is what we're kind of basing it on.
Yeah.
Every one of these offenses would be brought to the ADF, except for the cannabis, if we do write them under local ordinance. So I mean, you've got time and report writing, you've got all kinds of different added costs, and I think 300 is probably underestimating your costs. So if you wanted to do a cost basis, you could probably do that.
But those are the factors we have to take into consideration. Yeah, so we're not supposed to be in the profit-making business, so.
I don't think you're going to profit off $300.
Yeah, exactly.
In regards to your concerns, I think that's why the legislator put this in here. One thing, and maybe Mary can confirm or deny this, I mean, during the, they can appeal this during their DUI when they're found not guilty straight to that judge, I would think, instead of having to reappeal the case, and then if the judge gives us a court order to refund the money.
They can address the fees, yeah. The judge always has the authority to either impose the fees or not. In most, there are certain fees that are mandatory. This would not be a mandatory fee. So if the judge doesn't award it, we won't get it.
That way the person doesn't have to appeal it
So,
to a separate court hearing.
So what you're saying is when they go to court,
It'd
this
be up
is
to
already,
it'd be up to the attorney.
and this would be an administrative adjudication also, where the adjudicator would say, exempt the fees?
Well, no, the person, as I said,
You're saying they have to appeal it and then go to a court?
No, a DUI will take anywhere from 6 months to a year, so I'm pretty sure the person wants their car back before then, so they would pay the fee.
Right.
During the trial, if they're found not guilty, they can address it with that trial judge on getting their fees refunded. A court order came back to the county, to the administrative hearing officer, or to the person who's in charge of finance, saying refund this person's fees on that.
It sounds like that'd be a logical step.
That way there's not an extra hearing, but he will have to post, or he or she will have to post that bond prior to the DUI.
Well, I figured that would happen, but I was talking about getting the money back, not so much.
If a judge gives us a court order, I would think that the county's gonna follow the court order.
Oh, sure.
Yes,
If
the
it's
innocent
done
guy
all
could
once,
ask.
then it's fine. You know, I just don't want to see people have to take off work and go to court again for something they didn't do wrong.
What
You
do
know,
you
I mean,
think?
this, you know,
if
It's
it's in
real
the
simple, though.
circuit
It's gonna
court,
be-
in criminal court, it's just part of the finding. When the sentence is entered, the judge enters a sentence including fines, fees, and costs. So if they're found not guilty, there's generally no fines, fees, or costs whatsoever, so there just wouldn't be any.
so the towing fees would be, and storage fees would be included in the fee.
Not storage, because they still have to go pay the company for the storage and the towing to get their
That's what
car
I was
back.
getting at, because if you didn't do anything wrong, and
That's
you
just-
got pulled over,
Yeah.
you're innocent, now,
Well, just for a point
You
of
pay.
clarification,
It's
I know
wrong.
it's a technicality, but you're never found innocent, you're found not guilty, and there is a distinct difference. It just means the state didn't prove its case. But that being said, if you're found not guilty, I mean, that's just like Mr. Bible said, there are costs to defending yourself. And unfortunately, you're out those costs. It's just part of the American judicial system.
but we're gonna write a law, we can fix the law when we write it. I mean, that's all, you know, all I'm saying, I know we'll talk about it later, but
Yeah.
we can fix the law when we write it. We don't have to write something that has a flaw in it. We don't have to say we're gonna do something we know could have bad
If the county
consequences.
board is willing to fund that, we have to do that.
And I
Yeah, so
understand
we'll
your,
go on our committee.
your feeling of righteous indignation and outrage at that there are costs to defending your rights in the American judicial process,
Well,
but there
we'll
just are.
discuss this later, I'm sure.
Okay.
Just don't confuse the towing and storage fees, because right now, if you're arrested on a DUI, you still have to go get your vehicle, and you're not found not guilty. The county does not reimburse the towing and
Right.
storage fees.
That'd be up to the judge.
I've never heard of a judge reimbursing towing and storage fees. On the administrative fee, that's an additional thing if he wants to overrule that. But the company, we have never been forced to pay.
Well, the statute doesn't even permit it. The statute says that the towing company will be paid. The statute says that.
Right.
They're not going to
Okay,
take
by who?
refunds. By the person who owns the car,
Does it
to
say?
whom the car is
But
registered.
where I have the problem is you're innocent.
The
So what if
statute
the-
doesn't
what if
address,
the
it
towing-
doesn't address
what if
that.
the- What if the fees end up being 2 Gs? So a person's
Unfortunately-
gotta go to a bank and borrow $2,000
I-
because you got
No, I-
fees
I
and
hear
you're
you.
innocent?
I hear
And
you.
you're innocent.
I hear you, but the statute says the
So
registered
why
owner
don't we
still has
ch-
to reimburse that
But
towing.
we are rewriting this, we're gonna write this thing, why don't we figure out a way of fixing it?
But that's what we'll be talking about, we'll be debating it. I think you'll be on the losing end of that argument, but you make the argument.
I've been on the losing end many times, and I'm not afraid of it.
But
But
Steve, you need to keep something in mind, like Mary said. You're not found innocent, you're found not guilty. That doesn't mean you're innocent. Just like you said, the gentleman didn't have an accident, but he did cross the yellow line. He's found not guilty. That doesn't mean he's innocent. There's a difference. And I
If you
think
forget
that's
your
what Mary's
glasses
trying.
one day and you're driving and you hit
And
the
I
yellow
screw
line,
up.
and I'm the cop and I go, oh, you know what, I think I'm gonna give you a ticket today. I haven't written any today, I'm gonna write you up. And you know what, I think you can't walk too good, so you can't pass the sobriety test. So I'm gonna write you up and take your car. Then
But
you're
I
gonna-
wasn't
then you're gonna be
innocent.
so mad you'll be going crazy.
But I
You'll
wasn't
be over here at
innocent.
this board screaming.
Steve, I wasn't innocent. You said it yourself. I forgot my glasses. If
I'm
I'm
just
not
making-
driving
you know
safely,
what?
I'm not innocent.
You're good. I was just saying glasses. I shouldn't have just said.
I could be in the debate team.
No, I hear you, and I feel the same way about, as you do on these things, that when you're an innocent person, you shouldn't have to pay to defend your innocence, but that's just the way our system is set up, unfortunately, so. But we can talk, because we can make an exception to it as policy of this county board if we want to. If you
We're gonna
have
need a
to
whole
go
meeting
it.
for this, I think.
Right, exactly, Mr. Criswell.
I just want to comment before everyone leaves. I think they do a great job. As a matter of fact, Homer Glen was just voted the safest city in the state of Illinois. And it's because we have the sheriff's department.
Yep.
Wow. Support.
Yep, I think our sheriff's department does a pretty good job, so.
Yeah, I want to make it clear, I like the sheriff's department.
I understand. I don't know any officer in the department is gonna risk their job and pull somebody over for crossing the yellow line and then not going through field sobriety or not having probable cause to put that person under arrest. It's a lose-lose situation for that officer, the department, and for the person that we're arresting, taking away their freedom. So-
And having ridden with you specifically on patrol, I know that you guys have a tough job out there, and there's not enough of you out there to, I think officer safety is a problem in the county because of your lack of numbers. And I don't think you're gonna go out there antagonizing people deliberately and putting yourselves at even more risk. So I just think you guys do a darn good job, so. Anyway, did somebody else have any other comments? Because I want you to be able to finish presenting what you want about this bill. And then we're going to move on, possibly talk about the court use fees. Because I want to take advantage of Mr. Sangmeister being in the audience. I want to ask him a couple things.
One other important thing is a vehicle not retrieved from a towing facility or storage facility within 35 days after the hearing officer issues a written decision shall be deemed abandoned, and the towing company can dispose of it as they can now under Article 2, Chapter 4, regardless of whether the vehicle was administratively towed or not. So they do have that, towing companies have that power right now. They can seek judicial review. Mary can speak about the judicial review better than I can. And that's really about it. They can enter a judgment if even if the vehicle is deemed abandoned. That is really.
Well, I appreciate the fact that you guys already have a dollar amount in mind as to the fees, the reasonable fee that the statute is talking about, and that you have, there's some specific statutory requirements for the procedures. I think you guys have it more finely tuned as to what procedures you might want us to adopt for this.
The sheriff did not want to be heavy-handed with the $500 fee. I know that if I figured out my costs, we would be at $500. There's no doubt in my mind.
I think Mr. Frislow would feel more comfortable, and frankly, I would be too, if in the calculus for that $300, you would tell us what factors you took into consideration, so that we know there's some objectivity to this. And we would like to have some kind of, we'd like to have a couple board members come over to the sheriff's department to help establish some kind of proposed procedure for the administrative part of this bifurcated procedure, because I know part of it's criminal and, well, semi-criminal. I don't even like think of misdemeanors as being criminal, but they are, guys, technically. But working with you for the administrative part of this. So
Yeah,
that,
one of the costs you have to take into effect now is we're gonna have, we put about 1,000 cars last year. We're gonna have 1,000 more people come through our front lobbies. We have 3 records clerks up there, they're the ones gonna be handling the towing aspect, where they're taking money, taking time away from the request from the state's attorney, from the phone calls that come in, filling other things. So I mean, this is not something that is not gonna take more time for the officer filling out more paperwork on the street.
okay.
It's gonna be more time in the records division, as I said, researching things.
And you'll be working with Ms. Tatro's office too? I mean, she'll probably assign one of the assistant state's attorneys.
I will
language
draft
to-
an ordinance, and I will
Okay.
give it to Ms. Tatro.
Okay. And then Mr. Freifeld was suggesting that we could try to get this ready for whatever board members we have in January, present to that board in January to pass this ordinance, vote on it at least, so we can be ready right out of the chute in January 2015, so we don't waste any time on this. So, but I hate to skip a month and when we could be doing this. So I'm presuming I will be here to vote on it in January. But whatever the case might be, I want us to have some legislation ready to be voted on in January. So I'd like to be working on this.
And the nice thing about having the cost is, 20 years down the line, when there needs to be an increase, we know what we based it on.
Yeah.
This time. And we can use those same parameters.
Okay, all right. I thank you, Lieutenant, for coming over this
Thank you,
morning.
Rick.
I know you got things you got to do, so appreciate it. All right. Mr. Sangmeister, would you mind taking the seat for a moment?
The hot seat?
Yeah. Just want to ask you, because you know the court fee law got passed.
Yes, sir.
We need to discuss in this committee how to help you over the courts and the chief judge establish a schedule, and what you need us to know in getting an ordinance put together, so that we can maybe next month start working on that, and what amounts you had in mind and how you base those and that sort of thing. Could you tell us what you're planning on it?
Well, the legislation specifically talks about a fee anywhere from $1 per affected case up to a maximum of $30 per affected case. I can tell you, in speaking with the chief judge, that his recommendation is that the board consider setting the fee at $25. Right now, we don't, I had not calculated, I just got the agenda, so I knew this was going to be on Friday, but I haven't had a chance to get with Pam and her people regarding the number of cases, but I can tell you that a general working number for that, based on that $25, is going to be around $2 million a year, is what kind of revenue that'll generate. We can refine that a little bit, we can work on it this week. I can also tell you that, generally speaking, for every $5 increment, so if you were to go up to the 30, you're probably talking another $350,000 to $380,000. Just to give you an idea of the number of cases you're talking about. Somewhere in the 75,000, give or take, range per year.
And those funds are going to be on deposit with Pam McGuire's office in a trust fund of some sort into the Treasury?
There will be a special fund created once we set this up.
Okay.
And obviously that goes into the Judicial Facilities Fee Fund, and that'll be used for a specific purpose.
Okay.
With the concurrence of the Chief Judge.
And this is going to require, though, a county ordinance, though, right?
Yes.
And empower you to do it?
Yes.
All right. And who's going to draft the ordinance? Is it going to be you working with Mary Tatro?
I can.
We're gonna work with the state's attorney's office and with Kurt and the chief judge. get that ordinance, just as with the prior ordinance, to
Okay.
use for review in advance of January. So come January, you can meet that.
Okay, great, all right. So Chief Shane's already got that underway. We're gonna be ready to go out to shoot in January.
We'll work on it. He is recommending the fee, as I had mentioned, to $25. Obviously, the board sets that fee. If it's anything other than that, I think he'd like to participate in the discussion.
Sure. I think that's probably going to meet with the approval of this committee and with the full board. I don't think this board is pushing for $30, but we'll see. I could be wrong, but I think that's going to be with the approval of the entire board, a $25 fee. I don't think they like to go to maximum fees unless it's absolutely necessary, so. Okay, anybody have any questions? All right, well, thank you, Kurt.
Thank you very much.
All right. Any other new business that, I don't know about that?
We haven't had any, at least I haven't had any calls from Christmas time before that about administrative adjudication. It seemed like whatever was going haywire has been repaired, which is great, that's what we want to hear. Because frankly, people only call a county board member when they feel like there's an injustice. They don't call you when they're wrong. They call you when they think they're getting screwed.
Yeah.
So, but anyway, what I was wondering, is it possible that you could get this committee on a monthly basis, the minutes from the adjudication hearings? And then we could, just get them instead of, wondering what's happening. We could all read them and we'll know exactly what's going on.
Okay.
But like I said, there is no problem, so I'm not saying to do this because there's a problem.
You just want to monitor it.
I just want to, yeah, but I don't see any problems. I'm not hearing anything bad. Only positive because nothing's happening.
Okay, I'll put in a request for it. Yeah, because it can't work that process if we don't have the support of the public, so I'm glad to hear we're not hearing any complaints about it.
So I'm not getting any. I don't know if anybody else is.
I'm not either.
I'm not.
Great. All right. Anybody else have anything? All right. I don't have any announcements other than that it's tax day, folks, property tax. I know it's your favorite day of the year. So make sure you get down there and pay them. Otherwise, I guess I'm open to entertaining a motion for adjournment.
Move to adjourn.
Second.
All those in favor? Aye. All right. Opposed? None. All right. Thank you, everybody. Thanks, fellow board members, committee members. Have a good one.